Senate Committee on Criminal Justice is now reconvened. So invited testimony is closed. We will now chair open public testimony. Chair calls the following witnesses. This is on Senate Bill 1124. Amy Waddle, Joe Patton, David Gonzalez, and Brady Mills. Amy Waddle, Joe Patton, David Gonzalez, and Brady Mills. Thank you all for being here. We'll begin on my right, and you state your name and who you represent, your position on the bill. You have 2 minutes.
Thank you. My name is Joe Patton. I am an attorney with the Capital Murder Division of the Dallas County Public Defender's Office, and I am opposed to SB 1124. Would you like me to continue, or are we going?
You have 2 minutes. You just.
Okay. Well, before we begin, the invited guests had spoken a bit about Michael Morton and their interactions with him. There was an implication that Mr. Morton would support SB 1124 and that he felt somehow victimized by his name being used in the capacity as represented by the invited.
Could you move the microphone just so we can hear if we want to hear you?
Yes.
Thank you.
It was indicated that Michael Morton supported this and that there was a personal conversation that Michael Morton feels somehow abused or used up by defense counsel with his name and the discovery. Given that, I actually called Michael during the break, and he gave me permission to tell the committee that he does not support this, that he is familiar with it, and he does not recall making those statements. So I want to begin with that. Michael does not support this. Now, if the intent of SB 1124 is to reduce ambiguity and avoid, as the invited witnesses stated, unfavorable judges, SB 1124 fails. The question presented is not whether evidence exists. The question presented is who is responsible when there are evidentiary failures. And the current legislation shifts the burden and the responsibility off of prosecutors and onto judges and potentially law enforcement. Under the current law, prosecutors have, as they stated, a duty to seek justice, which means they have a duty to know their case and they have a duty to know their evidence. When they have evidence under the current law, they are to disclose it. That is the end of the analysis. There is no ambiguity. If it exists, you disclose it.
Thank you, sir. Perhaps there'll be some questions in the follow-up. We'll listen to all the witnesses, and then if there are questions, we'll come back. Thank you for your testimony.
Thank you.
You may proceed. Your name, who you represent.
Thank you. My name is Amy Waddle, and I work for the Montgomery County District Attorney's Office. I'm in the appellate division there, and I also participated on the committee that helped to draft a response to the Heath decision from last summer. Just in response to the previous comments, there is actually ambiguity in the current version of 3914 as to who in the state is responsible for conducting criminal discovery, at least under the interpretation of the state and Heath. So it is necessary to clear up the roles and responsibilities between the different members of the state, and this bill does that. This bill also does not curb the discovery rights given under the Michael Morton Act. It does curb the power of trial judges to penalize the community for inadvertent and ultimately harmless discovery violations. I think there was some mention earlier of the just increased volume of disclosures of evidence to be given over, which is going to lend itself to more violations. And so what do trial courts do when that happens? Well, there used to be a body of case law that set rules for trial courts to follow when a discovery violation occurred. Under those rules, the appropriate remedy for most violations, like late discovery or late disclosure of evidence, was a continuance for the defense to review and prepare to meet that newly disclosed evidence. Under those rules, exclusion of evidence was considered an extreme remedy that was reserved only for situations involving a willful, bad faith withholding by the state, or when the defendant was actually harmed by the late disclosure. But Heath upturned that body of case law and kind of pretended like it didn't exist and declared for the first time that trial courts have the inherent authority to elect this extreme remedy of exclusion of evidence, regardless of whether a lesser remedy would suffice, regardless of whether the trial prosecutor knew about the evidence and intentionally withheld it, and regardless of whether the defense was actually harmed by the withholding. And that's a key here because the idea of harm is familiar.
Finish your sentence, please. You can finish your
The idea of harm is familiar in criminal law. Trial errors happen, and the law recognizes that each trial error is not automatically reversible. But the Heath decision essentially made discovery violations essentially a basis or explicitly a basis for exclusion. And that is just not consistent with anything else in our law.
Thank you. Yes, please.
Hi, I'm David Gonzalez with the Texas Criminal Defense Lawyers testifying in opposition to the bill. One of the things that made the Michael Morton Act such great public policy is it recognized that discovery doesn't belong to the lawyers. That it really took this idea of particularized discovery that the civil lawyers fight about into portals, which you talk about. So then we're uploading all of the data because there is so much on these devices that everybody is recording. And there's no longer these individualized reviews. I'm reviewing it. My paralegals are reviewing it. Like last week when the prosecutor was unaware that on the body cams, the officers say to one another, I hope somebody watches this. This kid should not have been arrested. They can play this in court. The brass above me, they disagree, but my decision, his decision was not to arrest. And until you watch 7 hours of those videos, it's very hard under the changes. There's 8 changes to the Michael Morton Act here. 5 are unrelated to Heath, and those are the 5 that we're focusing on, which make discovery more narrow than civil discovery by requiring specificity, by saying I have to prove why it's necessary to my defense. To navigate privacy interests that we don't have in civil cases, that the court can't order more discovery. But, you know, as to Section Q, I agree. It is a fantastic guardrail to say normally we have spoliation instead of exclusion. But if it was just that, I think our organization would stand down. It's the narrowing that moved 10 years ago to where everything had to be specified to this moving of all the portals that we would say that we should be consistent like we're doing with crime lab discovery. Thank you very much.
Thank you. Thank you for your testimony.
Good afternoon, Mr. Chairman, members. My name is Brady Mills. I'm the Chief of the Crime Laboratory Division of the Texas Department of Public Safety, and I'm on the bill. I'm here as a resource to address any questions. But in context to the Crime Lab portal, we reviewed the bill, and there's a couple points that that may interact with the portal, but our assessment is that it doesn't adversely impact the portal. The portal will provide crime laboratory records in real time once they are administratively reviewed. The point that there has to be a written notice of discovery by the defense to the prosecutor, that still could work with the portal. Today, the prosecutors have to tell us who is the attorney on record, and so that written request from the defense attorney could be that notification to the prosecutor, so then we can give them access to the portal. The second piece about limiting discovery, the records that are automatically put into the portal, we would view, and we're working both with stakeholders from the prosecutors, from the defense, and then also from our laboratory and our local partner laboratories, is that the records that would be in the Crime Lab portal would not be in the burdensome or unduly broad category. And so that's how we have evaluated the bill, and be happy to answer any questions.
Thank you. Questions, members? Senator Huffman? Yeah, for anybody on the panel?
Just on the portal, if I may.
Senator Mendoza?
So on the portal, this bill itself would not have any kind of impact or cause any issues as it relates to the evidence that's put in the portal by the prosecutor. It's accessible to the defense. And
Yes, if we could all, and we will all agree that it's not unduly or unburdensome type records that are in the portal, those will all be freely accessible by defense and prosecution post admin review of the cases that are worked in the laboratories.
so what happens if the court rules that it's burdensome and the evidence already in the portal? How do you deal with that?
So we would have to work with the courts and educate of why those records are automatically in the portal, but then we would have to comply with the order from the court.
Okay, so you don't have any issue the way it's written in terms of as it relates to the portal?
The only maybe potentially clarification is that we could exclude crime laboratory records from this bill, but if as we work through this with our stakeholders and we make agreements that the records in the portal are not overly burdensome or unduly broad, then we feel that we would be okay with those records.
Okay. Thank you, Mr. Chairman.
Thank you all for taking the time to drive all this way to come testify and give us your sage advice. Thank you.
Thank you.
Thank you.
Chair now calls Jarvis Parsons, Staley Heatley, Sam Bassett, and Emily Follansby. Emily Follansby. Did I pronounce that right? Yes. All right. I used to use phonics. We'll begin on my right. Welcome to you all, and please state your name, who you represent, the position on the bill, and you have 2 minutes.
Yes. Thank you, Senators. My name is Jarvis Parsons. I'm the Brazos County District Attorney. I am for the bill, and I'll start my 2 minutes. Thank you so much. I fully agree with my colleagues, Mr. Ligon, Mr. Middleton from Fort Bend County, and Mr. Dick from Williamson County, that this bill provides clarity and balance. One of the things that I believe is sorely missing right now in the state of the world post-Heath. We're here to provide that balance and separate unintentional conduct from intentional conduct and give us a scalpel instead of a sledgehammer, where many times evidence is suppressed even without anyone even knowing. I know in my area of the world, in Brazos County, we've had situations where we didn't even know about evidence on a person who was doing what we would call upskirting and going around to hundreds, almost thousands of women in our particular area. And we didn't know there was evidence there at the police station that confirmed many, many more images. And that evidence is then suppressed without any sort of intentionality on the prosecutor's part or on law enforcement's part. And so I think that clearing that up is super important. It allows and kind of gives clarity for a standard for judges to see that if they are going to suppress evidence, it's going to be because of fault on behalf of law enforcement or on behalf of the state of Texas, the prosecutors that are there. And in instances where it is not there, then a continuance, which was the remedy before post-Heath, is going to be something that is balanced, it's reasonable for both sides, so that defendants get justice, victims get justice, and the state of Texas all get justice. And the whole point of the criminal justice system is to search for truth. And so in order to have that, we have to have the evidence that is there. Absent intentional misconduct, I think that this bill, Senate Bill 1124, strikes the exact right balance that we need. Thank you very much.
Thank you. Thank you for being here.
Good afternoon, Mr. Chairman, members of the committee. My name is Staley Heatley, and I am the Wilbarger County Attorney, and I'm here to testify in favor of the bill. I've only been county attorney for a few months now. Before that, for 18 years, I was the district attorney in the 46th Judicial District. In fact, back in 2013, I was here at the legislature testifying in favor of the Michael Morton Act. And I think what we've seen over the last decades is anytime you have a piece of legislation that creates kind of a sea change in the way you're doing something, is that you're going to see that there are some things that need to be fixed after you've been living with it for about a decade, and that's what we have here. SB 1124 will help protect against discovery gamesmanship that has become all too common in our criminal cases. It provides guidance and guardrails for courts in handling discovery disputes. I think we just heard some testimony about some evidence that was provided, some body cam footage that had some exculpatory evidence at the end of it. That kind of evidence will not be affected at all by SB 1124. That kind of evidence will continue to be provided. Section H of 3914, which requires the disclosure of exculpatory, impeaching, and mitigating evidence, is unchanged. I had a case just last year. There was a domestic violence case where a man had a long history of abusing women, and on the day of our trial, the victim showed up and she testified, and her testimony went sideways, which isn't really uncommon. But what I found out that evening when I got home and we were able to pull jail phone calls is that in the days leading up to the trial, he was coercing and threatening her. So when I got to court, I sent that information directly to the defense attorney, and I get to court, that evidence had been in the possession of the Sheriff's Department. And here I am facing a Heath motion on something I didn't know existed, that the defendant knew existed, and now that case is on appeal, and I'm battling that issue there. So I support this legislation.
Thank you, and thank you for being here. It's a long way to travel.
Good afternoon. I'm Sam Bassett. I practice law about 2 blocks from here, so it's not too hard for me to get here. I'm a former president of the TCLA, and I sat at council table when Michael Morton was found guilty. I saw his legs lock up. I saw him almost pass out. And at the time, I kind of thought he might be guilty. And I was on his team. But there was a lot that we did not know. And so the Michael Morton Act comes along 25 to 30 years later after he serves 25 years in prison, and we begin to do an inventory of what can we do to incentivize the full disclosure of evidence. And we worked hard and a long time on the Michael Morton Act. And I understand the Heath decision has caused a lot of consternation. As I read Heath, it was a case that had had 3 prior jury settings. It was the 4th jury trial setting. A timely discovery request had been made many months before, and the judge decided, for whatever reason, that he was going to impose a sanction of excluding the 911 call that the prosecutor had learned 6 days before. Now, nobody said the prosecutor was acting in bad faith or knew about it before 6 days before, but I think that the judge felt the overall system, the state, as the judge saw it, was more than just the prosecutor in the courtroom. And I think that's the essence of the Michael Morton Act, is that we need to incentivize all law enforcement working on a case, police officers, arson investigators, give them the highest incentive possible to comply with discovery and Michael Morton Act. The Brady rule existed when Michael Morton was tried. We filed discovery motions which were ruled on. So we're not talking about basic discovery, we're talking about incentivizing the system to make sure that everything is turned over. Our concern at TCLA is this gives too much discretion to DAs to determine what is relevant information to be turned over. As we do it now, it's a lot simpler of a standard. Material evidence is to be turned over. Thank you for your time.
Thank you. So we're showing you're against the bill, sir?
Yes.
Thank you.
Hi, I'm Emily Fonsby. I'm the legal director of Texas Defender Service, and I am testifying against the bill. Senate Bill 1124 would roll back Michael Morton Act, and it would do so in 3 critical ways. First, the bill narrows the definition of what the state is to just the prosecuting attorney and original investigating law enforcement agency. This change creates an inadvertent incentive for other state actors with relevant information to potentially delay or entirely withhold it from the prosecution. If the attorney representing the state does not seek that information, the defense is left in the dark, an outcome we know contributes to the incarceration of innocent people and undermines public safety. Second, Senate Bill 1124 requires the prosecution to hand over only evidence, quote, relevant to a fact of consequence. However, this standard is problematic because it assumes the prosecution can accurately assess what is relevant to the defense without knowing the defense's theory of the case. Defendants have a constitutional right to present a defense, and the defense, not the prosecution, is in the best position to determine what evidence may support or undermine its case. Limiting discovery to what the prosecution deems relevant risks withholding material that could be critical to innocent defendants. Third, the bill requires the defense to make a specific written request for information. But how can a defense attorney request something they don't know exists, let alone narrowly tailor such a request as required by the amendment to Section A2? This provision creates a catch-22, one that denies defendants fair access to evidence and reduces transparency and accountability in the discovery process. All 3 of the proposed changes in Senate Bill 1124 strike at the heart of Michael Morton Act, undermining its spirit, weakening its protections, and destroying the balance it was meant to restore. The Michael Morton Act brought long overdue accountability to the discovery process in Texas, accountability that the bill would effectively erase.
Thank you. Thank you for your testimony. Any questions, members? Thank you all very much, and thank you for taking the time to give us your advice, counsel.
Senator Huffman.
Chair now calls Caitlin Baker, Jenny Andrews, and Chase Baumgartner. Caitlin Baker, Jenny Andrews, and Chase Baumgartner. So we begin on my right. You state your name, who you represent, your position on the bill, and you have 2 minutes.
My name is Chase Baumgartner. I'm a staff attorney for the Innocence Project of Texas, testifying against the bill. As this committee knows, the Michael Morton Act is legislation born out of a wrongful conviction where a man spent 25 years in prison for a crime he did not commit. And as such, it hits close to home for our organization. And Senator Huffman, you stated that your intent was not to narrow the discovery obligations under the Michael Morton Act, but we share Senator Hinojos's concerns that it does for 3 key provisions. One, you just heard, that the changing of evidence that must be disclosed from material to relevant to a fact of consequence does narrow what must be produced in discovery. And for that same reason is prosecutors will now be making subjective determinations of what is both relevant and what is a fact of consequence. And unless evidence meets both of those standards, they can withhold it legally from the defense. And we know what the inevitable answer is when you withhold this evidence, is that wrongful convictions will happen. The second is that discovery will only happen if the evidence is not unduly burdensome to produce. But this legislation deals with evidence that is either material, if unchanged, or relevant to a fact of consequence, if changed. So this is important evidence, so how is it ever going to be unduly burdensome to produce this important evidence for a defendant to have access to? And this is exactly why the Michael Morton Act exists, because when you limit discovery on this type of evidence, wrongful convictions happen. And the third reason is we have a competing interest of a core tenet of our criminal justice system, not to convict innocent people, being balanced against privacy interests of witness and victims. But the law already provides ways to protect these rights and these interests. That information, that sensitive information, can be redacted prior to ever being disclosed to defense or being used at trial. And so limiting discovery in lieu of, say, redaction is not a suitable way to do this. Thank you.
Thank you. Thank you for your testimony. Whenever you're ready.
Good afternoon. My name is Caitlin Baker, and I'm here not as an attorney, but as a lay person with a vested interest.
Yes, ma'am.
We all know the story of Michael Morton and his wife, Christine. 17 months after Christine Morton was murdered, my mother, Deborah Baker, was murdered by the same man. The reason that was allowed to happen was because there was a prosecutor in Williamson County who intentionally withheld information in discovery, and Michael Morton was wrongly convicted. The person who murdered my mother should and could have been arrested in 1986. That evidence was already in the custody of the district attorney's office and of the police, but it was not turned over to the defense as it should have been, and the wrong man was sent to prison and allowed this man, this murderer, to walk free for decades. Deborah was my mother. My brother and I were very young and we needed her. And that her death was preventable makes it so much worse. And we had to wait 28 years, 8 months, and 11 days to bring her killer to justice because someone else decided what was relevant to the defense. Someone else, a prosecutor, made a mistake and decided that it was not relevant. And so for that reason, I have to urge you to vote against this bill as written. Thank you.
Thank you, and we're sorry for the loss of your mom, and thank you for having the courage to be here today. Yes.
Good afternoon, Senators. My name is Jenny Andrews, and I'm testifying today on behalf of the Texas Catholic Conference of Bishops, where I am a policy analyst. We are opposed to SB 1124, which we believe does roll back key provisions of the Michael Morton Act. This act was passed unanimously through both chambers in 2013 as a result of a grave miscarriage of justice in the case of Michael Morton, who was wrongfully convicted and imprisoned for 25 years. The Texas bishops support criminal justice reform that provides for compassionate treatment of prisoners, responds to the needs of the victims of crime, and encourages rehabilitation and forgiveness of those reentering society. The strength of our criminal justice system depends on its accuracy, its ability to convict the guilty and to clear the innocent. But we know that wrongful convictions happen. Identifying and understanding the causes of wrongful convictions is critical to maintaining the integrity of our justice system, and every effort must be made to ensure wrongful convictions do not occur. Since 1989, in the United States, 3,659 innocent people have been exonerated after they have spent years in captivity. Thousands more are awaiting exoneration but lack proper representation to achieve justice. It's estimated that 2 to 5% of people in prisons are actually innocent. Of the almost 500 that have been exonerated since 1989 in Texas, half of the exonerations were cases where the prosecutors had exonerating evidence in their possession at the time of the trial. The gravity of such a miscarriage of justice cannot be overstated. Condemning the innocent makes a mockery of justice, robbing men and women of their dignity, relationships, time, opportunity, and personal freedom. Wrongful convictions also endanger the public, because locking up an innocent person means the real culprit walks free. The TCCB's concerns are related to the limitation to a defendant's request for discovery in the bill as filed.
Thank you. Thank you for being here. Senators, any questions of these? Thank you all for being here. Thank you for your testimony. So there are no more witnesses, public witnesses registered. Is there anyone present here that wishes to testify on, for, or against Senate Bill 1124? Hearing none, public testimony is closed, and we will hold the bill pending till we get more of a quorum. Well, we have a quorum, but we're going to hold the bill pending. Let's move on to the next item of business. Thirteen seventy-two. Chair lays out Senate Bill 1372 and recognizes Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman and members. Last session, we passed Senate Bill 991, which charged the Texas Department of Public Safety with establishing a centralized crime laboratory portal to process record requests. This portal will facilitate the secure transmission of information among relevant parties, including laboratories, prosecutors, and defense attorneys. However, there's a current legal conflict in statute. Under the government code, which creates a portal, a defendant or the attorney is permitted to access and use the portal. Meanwhile, the Code of Criminal Procedure, Article 3914, which is a discovery article, a pro se defendant may only inspect and review materials when ordered by the court, but is not entitled to electronic duplication. This discrepancy has caused confusion regarding proper access protocols. Senate Bill 1372 resolved this statutory inconsistency by striking the defendant from Government Code Article. The article allowing the defendant's attorneys to access the crime laboratory portal to request any crime laboratory records. This change aligns this section with the obligations and intent of Article 3914, the Criminal Code of Procedure.
Members, any questions? Not, the chair lays out for invited testimony. We have Brady Mills. Chair calls Brady Mills. Welcome again.
Yes, Mr.
Your
Chairman.
name, who you represent, and any comments you may have.
Yes, sir. Mr. Chairman, members, my name is Brady Mills. I'm with the Texas Department of Public Safety Crime Laboratory Division. I'm on the bill as a resource and be happy to answer any questions.
Members, any questions? Any questions? No questions. Thank you.
Thank you, Mr.
Thank you
Chairman.
for being here. Seeing no other invited witnesses, invited testimony is now closed. Chair now opens up for public testimony. I see no one registered on this bill for public testimony. Is there anyone wishing to testify on, for, or against Senate Bill 1372? If not, hearing none, public testimony is closed, and we'll leave this pending. Chair now lays out Senate Bill 1936. I recognize Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman. Senate Bill 1936 relates to the definition of an abuse unit for certain controlled substances under the Texas Controlled Substances Act. Under current law, the Texas Health and Safety Code defines an abuse unit for penalty group 1A substance, such as LSD, based on how the substance is applied to the carrier medium, typically blotter paper. If the paper is perforated or marked, each individual square is considered one abuse unit. However, if the paper is not perforated or marked, the law defines an abuse unit as each quarter-inch square section of paper, requiring labs to manually measure and count the dimensions of the sheet. This approach introduces inconsistency in lab analysis and can complicate prosecution, as officers and forensic experts must estimate dosage units based on the physical size of unmarked paper. By shifting from a dimensional to a weight-based definition, the bill aims to provide a more uniform, scientifically reliable method for identifying and charging offenses involving LSD.
Thank you. Members, any questions for the author? If not, my invited testimony is now open. The chair calls Brady Mills. And the good thing you're right nearby. Any questions? It's at your name, who you represent, and any comments you may have.
Mr. Chairman, members, my name is Brady Mills with the Texas Department of Public Safety's Crime Laboratory Division. Here's a resource on the bill. Be happy to answer any questions.
Any questions, members? Thank you.
Thank you.
There, seeing no more invited witnesses on the list. Invited testimony is now closed. Chair now opens up for public testimony. There are no one registered to testify for public testimony. Is anyone present here to testify on, for, or against Senate Bill 1936? Seeing none, public testimony is closed, and we'll leave this bill pending. Chair now recognizes Senator Huffman. Senate Bill 552 recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, regular community supervision, deferred adjudication, community supervision, and community supervision for state jail felonies are three different forms of post-conviction community supervision programs in the state. Under current law, certain individuals are not eligible to participate in some of these programs, including those convicted of crimes with a sentence exceeding 10 years, certain violent offenses, especially those against children, repeat offenses of some specific types, DWI offenses under certain conditions, and drug offenses with prior convictions for similar offenses. So there are certain individuals in the state that currently under the law are not eligible in different forms for these post-conviction programs. Senate Bill 552 would amend the Code of Criminal Procedure by making illegal aliens, as defined by the bill, ineligible for judge-ordered or jury-recommended community supervision, including deferred adjudication, community supervision. The bill defines an illegal alien as someone who either entered the U.S. without inspection at an unauthorized location, or was admitted as a non-immigrant but failed to maintain their legal status or comply with conditions before allegedly committing the offense. Because these individuals entered the country illegally, the state should not be funding their early release and enabling these offenders to re-enter our communities. That's it.
Any questions, Senator Hinojosa? No questions? Are there no questions? I see no one for invited testimony. So invited testimony is open and closed. Now the chair now opens up for public testimony and calls up Adam Haynes, Charles Reed, Crystal Gomez, and Daniel Woodward. Adam Haynes, Charles Reed, Crystal Gomez, and Daniel Woodward. Welcome. Thank you all for being here. We'll begin on my right, and if you state your name, who you represent, and your position on the bill, and you have 2 minutes. You
Sorry.
you can move the microphone so we can hear
Yep.
you.
Charles Reed, here on behalf of the Dallas County Commissioners Court to testify in opposition to Senate Bill 552. Our opposition is primarily based on concerns for the Dallas County taxpayers. Taking away community supervision as an option will increase the length of stay in county jails for individuals who are convicted of crimes that are served in the county jail. As of this morning, Dallas County has 6,670 individuals in our county jail. We have a maximum capacity of 7,100 or so. We believe that taking this option off the table will likely force us to export custody of inmates in Dallas County Jail at a very expensive cost to the taxpayers. Our budget office estimated that this could cost taxpayers in excess of $100 million because it will take us over our jail limit that's authorized by the Texas Commission on Jail Standards. We believe that there are ways to manage this population that don't include custody, like GPS monitoring or potentially even the state reimbursing counties for these folks that would have otherwise been on community supervision. But just from the taxpayer's perspective, we are very, very concerned about the implications that this bill would have on our jail population and then ultimately the taxpayers of Dallas County. And with that, I'd be happy to answer any questions.
Go
Senator Huffman.
later, can I?
Go ahead, Senator.
Yeah, so if you, this is interesting testimony.
Yes.
So if you think it's gonna cost $100 million, how many illegal aliens do you have on probation in Dallas County?
So the numbers that were run locally were that there were about 3,000 individuals on community
3,000.
supervision in Dallas County. Yes,
And you
ma'am.
do understand that community supervision also has a cost too, both to the locals and to the state.
Correct, and it is a far lower cost than custody in our county jail, but yes.
But it is a cost, because I can tell you in the current state budget, there's $753 million of the state spend on, this is just adult probation, and about $376 million in local spend. What percentage of that is Dallas County? I couldn't say off the top of my head, but you know, the big counties tend to have a higher proportion, as you well know. But I think you're making my point that there are thousands of illegal aliens on probation in Dallas County. Is that correct?
Yes.
Yes. And by definition, when you're on probation, you're not supposed to be doing anything illegal or that you're not supposed to be doing. So if you're in the country illegally, you're already violating your probation. Correct?
I can't comment. I'm not an attorney, so I can't comment on that nuance, but
Well, I think
I'll
common
take your
sense
word
could
for
probably
it.
answer
Yes.
that. I mean, I'm not going to argue with you about it, but I think people understand what I'm saying. If you're in the country illegally, you know you're in the country illegally. So, okay, but there are thousands on probation. That's Dallas. Okay, thank you. Thank you for
Thank you.
allowing me to ask a question.
Any other questions? Please proceed, ma'am. Thank you.
No problem. Thank you. All right. Thank you, Chair and committee members, for the opportunity to testify on SB 552 today. My name is Crystal Gomez, and I'm representing the Texas chapter of the American Immigration Lawyers Association and the Texas Immigration Law Council. I'm an immigration attorney, and I'm here to raise our concerns about this bill's overbroad definition of illegal alien. The definition in this bill conflicts with federal immigration law in two critical ways. First, by including anyone who entered the United States without inspection, it fails to recognize that many such individuals now have lawful status, including legal permanent residents, DACA recipients, TPS holders, asylees, and those granted humanitarian visas as victims of crime, trafficking, or domestic violence. Second, by including anyone who failed to maintain non-immigrant status, it would wrongly encompass individuals with pending applications who are in periods of authorized stay, and those who may have violated their status in the past but are currently in lawful status as illegal aliens. Procedurally, this definition also presents a nightmare for state actors to try and disentangle. It's very difficult for even federal actors to get these questions right, and wrestling with immigration law is their entire job. Let me illustrate with real-life example. I represented a client who was initially found to have violated his visitor visa when he mowed his cancer-stricken aunt's lawn and received $20 from her in thanks. CBP deemed this as unauthorized work and saying he violated his visa, but USCIS ultimately disagreed and they approved his application for adjustment of status. So this raises serious critical questions. Are Texas prosecutors and judges going to be required to review the complex immigration, work, and academic histories of various visa holders? Who's going to train them on the nuanced requirements particular to each visa category? What happens when they inevitably get it wrong? I urge this committee to amend the bill to exclude those with legal permanent residence, authorized periods of stay, or any lawful status, and to reconsider imposing this undue burden on our state judicial system.
Thank you. Thank you very much for your testimony.
Good afternoon, Chair Flores, members of the committee. My name is Danny Woodward, and I'm a policy attorney with the Texas Civil Rights Project, and I'm here testifying in opposition to SB 552 today. We oppose treating people differently in our criminal justice system based solely on their immigration status. The INA is a complex body of law that imposes largely civil consequences, and it is not designed to be mapped onto states' criminal laws. Furthermore, the complexity of federal immigration law will make it difficult for state judges and prosecutors to administer the requirements of SB 552. Federal immigration judges receive training to determine if a person has violated the terms of their visa or has committed other violations. This bill would put these complex determinations into the hands of state magistrates and judges who have not had such training. And worse, the definition of a legal alien in this bill is overbroad and does not clearly map onto federal immigration law. It wraps people who have lawful status in the United States. Magistrates will waste precious time and resources trying to make a determination that is best left to the federal government. Second, we oppose any bill that categorically denies release of people into programming designed to help reintegrate them into their communities. Studies show that incarceration actually increases the likelihood of future crimes. Judges and juries should have the discretion to determine when community supervision is the best remedy for both an individual and the community. Last, I want to note that this bill will likely balloon the population of Texas jails and counties at the expense while keeping people with ICE detainers from federal immigration custody and deportation, which goes against what I imagine the author of this bill wants in most cases, maybe not all. Thank you for your time.
Thank you for your testimony. Please proceed.
Thank you, Mr. Chairman. Adam Haynes with the Conference of Urban Counties, and we're here, unfortunately, to testify against 552. I'm going to take a little bit different tack than my friend from Dallas County did, and I'm going to argue, and I'm doing it on thin ice here because I've got the chair of finance and the vice chair of finance and members of finance, but we're going to talk about finances. As you know, Mr. Chairman, counties are your partners, and it's nowhere more so evident than in the criminal justice system. We will, if you pass this bill, we will implement this bill. But I just want to make sure everyone understands that if you pass this bill, it will be a massive property tax increase. Senator Huffman, I agree with you. The federal government has failed the state of Texas when it comes to our immigration laws. Check. You are correct on that, and I think just about every one of my county judges and commissioners would agree with you in that assessment. They have failed us. But what we ask is don't take the federal government's failure and put it onto the backs of property taxpayers. You've got 2 units right now at TDCJ that were converted to handle misdemeanors. They're almost empty. Utilize those facilities before you ask us to do it. And if you make this change, if you do this, then at least compensate us for the cost of holding these folks without the ability to do community supervision. Community supervision, there is a cost, but if you take the average cost of holding a prisoner, it's about $88, obviously more in Harris County, but it's about $88 statewide. And you use $30 a month, that's over it, and it's $88 and change. It's $2,500 a month just to hold the person. Community supervision is much less than that.
Senator Huffman.
Yeah, just a quick question. So You represent many urban counties. I'm assuming
Yes,
you
ma'am.
would agree that there are tens of thousands of illegal aliens on probation in Texas?
Oh, yes, ma'am.
Yeah.
Yes, ma'am.
Do y'all have an estimate? Does anybody keep the hard numbers?
I would,
I know Dallas had an estimation. I don't know how they came up with it, but I've had a hard time trying to get that kind of information. So I think it's very important to have this hearing, let the public know that there are tens of thousands that cost their taxpayer money now. And, every session, I've been chair now, finance a couple of sessions before that. I was on conference for these articles. And there's always a lot of begging and teeth gnashing for not enough money for probation, not enough money for treatment, not enough money for substance abuse. I think the public has a right to know that many of those resources are being spent on illegal aliens. It's the fact. So it's something that needs to be discussed, and it should be part of what we're talking about. I mean, a director of DPS was here today and said there's, 114,000 illegals booked into Texas jails right now. 11,000 active warrants, and everybody needs to know that some of these people are getting put on probation and we're paying for it and they're out on the street. So it's just part of the narrative here.
I think.
I don't mean to pick on you, and
No, I don't take it as
testimony. It's just-
again.
Yeah.
Yes, ma'am.
Maine.
I cede the ground, the point to you. The federal government has failed the state of Texas. And I understand, and I applaud you for doing something. I mean, we need to change our immigration laws. And I think every county judge that I represent, every county commissioner that I represent would make a similar statement. But what we ask is if you make this, and, we enter into a partnership agreement with you every 2 years. You have the ability to change that partnership agreement that we operate under, and you often do so every 2 years. And again, we will implement this bill, but it will be at a significant cost to property taxpayers. And you're right, we need to have that discussion. Yes, ma'am.
Be out there. Thank you.
Yes, ma'am. Thank you.
Senator Hinojosa.
And one of the things that probably we need is a better number as it relates to how many of those illegal aliens from probation or get arrested and charged with a crime would actually be put in jail. I know your suggestion of having some of the state facilities be used. In Hidalgo County, we have 2 units, the Segovia unit and the Lopez unit. And they're both state jail facilities. So we've been using them to house some of the immigrants that have been arrested up in, I forgot the name, up in Del Rio, up in the part of the state. So the state does have some room. I don't know exactly how much. And quite frankly, the Hidalgo County Jail is full. We're now leasing from Willacy County, one of the private jails. So it is a challenge. But at the same time, we just can't, some of them will become repeat offenders. So it's just an issue that's very difficult to manage. I'll leave it at that.
I think Mr. Collier and Mr. Wood would have better numbers on the total number than even, I do represent 35 counties and then individual counties, but they'd give you a better system-wide. All 3 of you have jails that have county jails that are shipping prisoners out, especially you, Chair, and it costs Harris County about $50 million. That they don't have, and Mr. Chairman, you've got jails shipping prisoners out, and obviously in El Hidalgo, being a big county and a border county, you get a double whammy. So yes, sir.
Thank you. Any more questions, members? Thank you all very much for being here. Thank you for your testimony. So the chair sees no one publicly registered to testify. Is there anyone here that wishes to testify on, for, or against Senate Bill 552? Hearing none, public testimony is closed, and we will pen this for now. Chair now calls up Senate Bill 1937. Is it 1937? By Senator Hinojosa, and recognize Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman and members. Senate Bill 1937 relates to the testing of evidence containing biological materials in capital cases. In 2013, Senate Bill 1292 required the state to perform DNA testing of biological evidence prior to trial in any capital case where the death penalty is being sought. While this mandate ensures that testing is conducted early, the law does not include the advice of a subject matter expert from the laboratory performing the testing. A subject matter expert could provide valuable information regarding the viability of any biological evidence. The guidance could remove the need to test evidence that is not sufficient to yield a usable result, enable cost savings, increase turnaround time for case samples. Code of Criminal Procedure, Article 38.43, which is the article containing the evidence containing biological material, requires the court to order the state and the defense to meet and confer about certain biological materials collected as part of an investigation as soon as practical after the defendant is charged with a capital offense. Senate Bill 1937 will allow experienced forensic experts to weigh in on what could be considered as biological evidence. It would require the court to include a subject matter expert from the accredited laboratory, which will be used to test the evidence to meet and confer with the attorneys as to what will be admissible.
Thank you. Any questions, members? Any questions? If not, the chair calls up invited testimony. Chair calls up Brady Mills, Texas DPS.
Mr. Chairman, members, Brady Mills, Texas Department of Public Safety, Crime Laboratory Division, on the bill as a resource. We're happy to address any questions you might have.
Any questions, members? Anything else? You have a question? Okay. Thank you.
Thank you, Mr. Chairman.
No more invited witnesses are listed. Invited testimony is now closed. Chair now opens public testimony. We have no one registered to testify publicly on this bill. Is anyone here present that wishes to testify on, for, or against Senate Bill 1937? Hearing none, public testimony is closed, and we'll leave this bill pending. Chair lays out Senate Bill 1806. The chair sends up a committee substitute for Senate Bill 1806. Is there any objection to adopting the committee substitute for Senate Bill 1806? Did he step out? Well, I guess he objected. I don't know. The author of the bill, yeah. Well, we'll just take a pause and let him finish. Maybe it's something else. We don't know.
I could probably lay it out. Well, I got the analysis.
And here's the actor. Then we're going to reverse and unlay out 1806 and wait for the author to get back. So which one was that? King. Chair lays out Senate Bill 1208 and recognizes Senator Huffman to explain the bill in place of Senator King.
Thank you, and members, I am laying this out as a courtesy to Senator King. Members, there has been a rise in incidents across Texas of individuals obstructing peace officers, emergency medical personnel, and public officials from performing their duties. This behavior raises concerns about law enforcement safety and effectiveness. When an individual interferes, disrupts, or impedes a peace officer's work, it hinders an officer's ability to maintain order and respond to emergencies. It is crucial to address this issue to allow peace officers to safely serve their communities. In Tarrant County, an individual who has been arrested 8 times for obstructing peace officers responding to emergencies. This person captures these interactions on video, escalates their confrontation with law enforcement, and profits by sharing content online. SB 1208 seeks to deter this behavior by increasing the penalty for the offense of interference with a peace officer or a public official's public duties. It increases it to a state jail felony from its current status. That's it.
Senator Hinojosa, you have a question? I guess he doesn't. Well, all right. Well, the invited testimony is now open. The chair now calls Christopher Britt and Lauren Lawrence. Christopher Britt and Lauren Lawrence. Thank you all for being here, and we'll begin on my right. Captain, and if you state your name, who you represent, and you may proceed.
Well, thanks for having us to begin with. Christopher Britt, as you mentioned, I'm captain with the Fort Worth Police Department. Best for me to explain why exactly I'm here is I'll give you a little bit of history of how I sort of got involved in this. So before I promoted to captain, I was a lieutenant over a patrol division where we had one of these, they refer to themselves as First Amendment auditors. Basically what they do is they engage interactions with police to video record and get views on social media and things like that. So particularly in the area I was in, we were having an issue with a handful, but one in particular. So we had to develop training for officers over this. It became such a big issue that we had to put our whole department through it because this wasn't something we encountered on a regular basis, basically. They were so aggressive, creating such a dangerous situation that we had to inform our officers how to handle it. So we did that, got everybody through it, started to handle those cases better, and then fortunately our prosecutor was able to take on these cases, start putting them in front of juries, and he was doing a great job getting guilty convictions. Issue is, though, the punishment wasn't much on the back end of it. So we were seeing he would call me up, hey, got a guilty on it, it's been handled, thanks for your help with it. That night I'm getting calls told, well, he's back out doing the same thing. I mean, within just a day. So that's essentially kind of the bigger issue of what we're running into. So I could sit here and describe to you what they're doing. If you're open to it, we have a video that we can show you actually what's taking place as opposed to my general description.
Well, if you're satisfied with your testimony and the fact that you're here, but thank you for offering the video, and maybe you want to offer that into the record, if you would, and that way we will have it.
We can do that, Chairman.
Thank you.
So I think I'm good. If you have any questions, I'll do what I can for you.
Senator Hinojosa.
What is the punishment right now for doing that?
It's a Class B misdemeanor.
Okay. And I guess you don't think a Class A would deter someone from doing that, interfering with an officer?
So, I would have to let them speak. I don't obviously prosecute these cases. I think we've bumped them up to a Class A. We've encountered the same issue, I believe. Isn't that correct?
Yes, Lauren Lawrence. I am here on behalf of Phil Sorrells, the elected district attorney from Tarrant County. We are also registered in favor of this bill. Senator Hinojosa, the problem that we're seeing, even if we bump it up to a Class A misdemeanor, is, and I can imagine this is happening in most counties, but every defendant in Tarrant County is getting 2-for-1 credit. And so what is 365 days, if you get a maximum punishment, is now automatically 6 months. And for folks in Tarrant County who are on their best behavior while they're incarcerated, they're getting 3-for-1 credit. So that is at the end of it, no deterrent at all for this behavior, especially when we see folks who are, as Captain Britt was mentioning, are getting an appeal bond and bonding out within hours of being convicted of this offense and proceeding right back to, going back out on the streets and purposefully finding investigations that they are not a part of and inserting themselves into those investigations and not only filming the officers, there's no problem with that, officers are filming themselves, right? But they are interjecting into the investigation, yelling profanities, getting close to these officers, and drawing their attention away from what could be an incredibly dangerous situation.
So you distinguish between just filming and somebody actually being more aggressive and interfering with the duties and responsibilities of a police officer.
Absolutely, and those are the types of cases we're seeing. These are not folks who are standing outside of the investigation with their phone up, just recording these officers. They are seeking out these investigations when they find officers out on the street just doing a random traffic stop. We've even got a video on here of officers attempting to execute a search warrant. They are approaching those officers, getting their attention, yelling profanities at them, and drawing their attention away from what it is that they are attempting to do, which is obviously a hazard for them, but it's also a safety hazard for the individuals that our officers are coming in contact with. So, because they also don't know who these folks are that are approaching the scene. So, yes, it is not just the filming. Again, we don't have any problem with that. You obviously have a First Amendment right to film officers. And like I said, they're filming themselves. But when you are intentionally inserting yourself into a situation and drawing attention away, it is a big safety problem.
Thank you.
Thank you. Senator Huffman, your light's on. You have a question?
Oh, I'm sorry.
Thank you. Thank you all very much. Thank you for being here.
Thank you.
And we'll get this submitted for the record.
Thank you. So seeing no other invited testimony, the invited testimony is now closed. The chair now opens up for public testimony. The chair calls up Kathy Mitchell and Julian Reyes and Kirsten Budwine. Kathy Mitchell, Julian Reyes, and Kirsten Budwine. We'll begin on my right. State your name, who you represent, your position on the bill. You have 2 minutes.
Hello, Chairman and members of the committee. My name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project here in opposition to SB 1208. SB 1208 increases the criminal penalty for the offense of interference with public duties from a Class B, which holds up to 180 days in jail, to a state jail felony, which holds up to 2 years in a state jail. Interfering with public duties is broadly defined as a person who interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty. People who film the police or protest are often charged with this offense. Protesting and recording police officers are both protected speech under the First Amendment and should not be considered felonious conduct. It is unfortunate that we are increasing the criminal penalty for what is not only protected speech, but is also oftentimes nonviolent conduct that poses no threat to law enforcement. This will have a chilling effect on the rights that we all hold near and dear to us. People will be deterred from holding officers accountable and protesting in fear of being stumped as a felon for the rest of their life. Rather than punishing citizens for the nonviolent conduct, we should be encouraging this type of conduct. For these reasons, we are opposed to SB 1208.
Thank you. Thank you for your testimony. Please proceed. Your name, who you represent, your position.
Hello, Chairman and members of the committee. My name is Julian Reyes. I'm a member of the Free Press, and I'm in opposition to SB 1208. I'm concerned with this bill's purpose of enhancing the criminal penalty from a Class B misdemeanor to a state jail felony. I question why this is necessary. Being charged with a Class B misdemeanor holds up to 180 days in jail and a substantial fine. Being arrested for any offense ruins lives. It's basically state-sponsored kidnapping for the First Amendment. This has been used as an abuse by law enforcement officials to discourage the transparency and hide their abusive conduct. This bill would, as the Supreme Court has said, this bill would encourage police overreach of the people's First Amendment protections. It would have a further chilling effect on press recording, audio, and video, and free speech. It would also cause a multitude of citizen harm, police corruption, protectionism, and erosion of civil rights. I've been falsely arrested multiple times for interference with public duties as a member of the press, and every time I've won my case in the interest it was shown that the LEOs used this offense to retaliate against me, and police retaliation is police abuse. Police abuse is supposed to be a crime. We shouldn't be legalizing it. Each time my case has been dismissed by the prosecutor's office in the interest of justice, which was written, I have been threatened by poorly trained LEOs more times than I can recall. Filming the police, which is protected speech and press, should never be criminalized, yet there is no clear message in the code to police, in this code, the statute, to the police about those protections. For these reasons and other reasons, I oppose SB 1208. Any questions?
Thank you. Thank you for your testimony. No questions, and thank you both for being here today, for your testimony. I'm going to call her one more time. So the chair calls Kathy Mitchell Kathy Mitchell. So she's not here, so we will move on. There's no one else registered for public testimony. Is there anyone here present who wishes to testify on, for, or against Senate Bill? Have you? Yes. If you have a card, have you registered? Make sure and fill. You make sure and fill out a card. Well, fill out a card. You can come forward. And state your name, who you represent, and your position on the bill. You got 2 minutes.
My name's Brianna Arredondo, and I represent myself. I oppose this bill because it's our constitutional right to film. Why do we have a phone? Why do we have constitutional rights if we can't exercise our right to film the police? You know, there's, like, I film the police all the time with my friend. And not only my friend, with the community, but me and my friend, we always film the police. And they have cameras. Oh, they got cameras. They're threatened by our cameras. We should be threatened by their cameras, you know, because by their weapons and their armor that they got. Why are they so threatened by a camera from the public? Why are they so threatened? Because they don't want the transparency out. They don't want the accountability to be shown about what they're doing, all the unjust that they're doing. You know, we as a community, we see, and they manipulate the media. They push their narrative. Oh, they have a weapon. Oh, there's a weapon involved. Oh, where's the weapon? The video doesn't show the weapon. There's no weapon. They're lying. They lie to the media. They lie to the news. The news are lying. They're in favor of the police departments. The corruption. They don't want their corruption exposed. That's why they try to silence people. That's why they try to scare people. We have every right, the people of this country have every right to film law enforcement on their duties. I oppose this bill. Thank you.
Thank you for your testimony. Any questions, members? Is there anyone else here wishes to testify on, for, or against Senate Bill 1208? Hearing none, public testimony is closed, and we'll leave the bill pending. We'll give it another go, Senator. Found him.
Thank you, Mr. Chairman. Yes.
The chair lays out Senate Bill 1806, and the chair sends up a committee substitute for Senate Bill 1806. Is there any objection to adopting the committee substitute for Senate Bill 1806? Hearing none, so ordered. Recognize Senator Sparks to explain the bill and the committee substitute.
Thank you, Mr. Chairman and members. So oil field theft has become a multi-million-dollar criminal enterprise affecting business across Texas. Cartels and other criminal organizations frequently target petroleum products, drilling equipment, and machinery, causing significant economic loss and safety risks. The committee's substitute to Senate Bill 1806 takes a comprehensive approach to combat the problem by giving law enforcement stronger tools, streamlined procedures, and tougher penalties. It allows for the immediate sale of seized crude oil and condensate at market prices to prevent loss or degradation, and ensures proceeds are handled under existing asset forfeiture laws. The bill authorizes specially trained officers to inspect cargo tanks suspected of transporting stolen petroleum and collect samples for forensic analysis, adding valuable investigative capabilities in the field. It also strengthens criminal penalties, making theft of petroleum products and oil and gas equipment a felony, with punishments escalating based on the value of the stolen products. Additional provisions make it a crime to transport petroleum without proof of ownership, engaging in unauthorized sales, or operating a disposal well without a Railroad Commission permit. Overall, this bill closes critical loopholes and enhances the state's ability to safeguard one of Texas' most important industries from organized theft and illegal activity. The committee substitute does two things, basically. The bill, as originally drafted, introduced a version that creates an offense for a person who continues using, begins drilling, or converts a well without a permit. The committee substitute changes that. It removes continues using and creates an offense only for someone who begins drilling, begins using, or converts a well without a permit on the saltwater disposal side. The second thing the committee substitute does is on page 1, line 20, it changes the shall to a may with regards of DPS selling the seized petroleum. We got feedback from stakeholders saying that where they shall sell that could be problematic, and because all kinds of rules and regulations already in place from the Railroad Commission that would make that a challenge, and so we're moving that back to a shall, to a may, a shall instead of may.
Senator Hinojosa.
Thank you, Mr. Chairman. Actually, Senator Sparks, this has become a big issue along the border with the fuel depots, where they are now blending oil that's and gasoline that's stolen. And testimony we heard, I think it was in finance, up in West Texas. There's also many issues with oil field theft and the theft of petroleum and oil, and quite frankly, our law enforcement, DPS, and the Comptroller's Office has jurisdiction over those type of activities. Don't have the proper equipment yet to be able to test some of these tankers, and they're falsifying a lot of the bills of lading. So we have several bills in border security that might also help out with this issue up in West Texas.
Yeah, very good. Yeah, I agree with everything you said. It's become a real problem, not just in West Texas, but in really most places around the state is suffering from various forms of oil field theft.
Yes. Thank you, Mr. Chairman.
Thank you. No more questions? At this time, the invited testimony on Senate Bill 1806 is open. The chair calls Sean Hallett. Captain Sean Hallett, DPS. Howdy. You say your name and who you represent, and you may begin.
I'm Sean Hallett. I'm a captain with the Texas Department of Public Safety, Criminal Investigations Division, here neutrally on the bill to answer any questions you may have.
Members, any questions? Any questions? Well, thank you for being here. There's no one else listed for invited testimony. Invited testimony is now closed, and there are two public members. So chair is now open for public testimony. Chair now calls Ed Longenecker and Michael Lozano. Good afternoon.
Good afternoon.
Thank you all for being here, and state your name, who you represent, your position on the bill, and you have 2 minutes.
Thank you, Chairman, and good afternoon, committee members. My name is Ed Longenecker, and I serve as president of the Texas Independent Producers and Royalty Owners Association, and very pleased to testify in strong support of Senate Bill 1806. As you heard in testimony last week and will today, oil field theft is increasing and causing significant concern and impact from a financial, safety, and even environmental perspective. This criminal activity is being conducted in a well-coordinated, organized, and sophisticated manner, often in rural areas of the state, making it difficult to identify, investigate, and prosecute these crimes, especially given limited resources for law enforcement. As an example, the sheriff of Winkler County told me he only has 2 daytime deputies and 2 nighttime deputies with 191,000 vehicles traveling through his county in a given month. And we both testified also with the sheriff of Howard County on another oil field theft bill in the Senate recently, and he indicated that his department is very much in need of additional training and related resources to address this very persistent problem. We received similar feedback even from the FBI from a resource standpoint. They have a team of experienced agents focused on this type of criminal activity, but they are also often stretched thin for resources. We believe a comprehensive, multi-pronged, and frankly aggressive approach is needed to address this type of criminal activity, including increased penalties, additional resources for law enforcement, including effective training techniques, related strategies, better tracking, improved collaboration and communication among stakeholders. This is a very comprehensive bill, and we think it will have a meaningful impact on this very prevalent problem, and I appreciate the opportunity to testify in support and thank Senator Sparks for his leadership on this issue.
Thank you, Senator Hinojosa.
Thank you, Mr. Chairman. You know, what's really interesting is now Mexico is starting to crack down on oil tanker trucks going south to Mexico to check the proper documentation, check to see what kind of oil they have and the proper ownership documents. So it is a serious issue and a very prevalent problem now dealing with cartels that not only on the Mexican side, but criminal organizations here in Texas.
Yes, sir. Thank you.
Thank you, Mr. Chairman. Members, my name is Michael Lozano with the Permian Basin Petroleum Association in full support of Senate Bill 1806 by Sparks. I want to thank you for the opportunity to rejoin you here today to talk about it, the work y'all are doing to help the oil field with growing sophisticated threats against industry all across this state, but in particular in the Permian Basin. Senate Bill 1806 is a couple of things I think that allow for the prosecution of the very unique theft that's occurring from oil and gas operators across the state, and specifically targeting the fact that we are seeing more and more activities occur at tank batteries or other locations. And really where that's happening is that transport, that illegal sale that's occurring, effectively laundering the crude, is really what's allowing this market to continue. And we think further emphasizing and limiting that threat, interdicting on that specific transport, sale, and use is going to be really imperative for our industry in attacking this crime. Additionally, as all of y'all have noted, this is a very sophisticated crime. There are individuals that are engaging in this in an organized manner. They're utilizing Railroad Commission records to falsify those records in order to launder it on paper, then of course sell it to those who are unsuspecting of that as well. We think in addition to that, law enforcement is presented with a unique challenge in that when these large volumes of crude are found and they're stolen, there's not really a great opportunity for them to store these in facilities that they can operate or manage or secure. And so that portion of the bill is also really important. We appreciate Senator Sparks for his leadership on this, as well as those of you that have been working on this with us, and of course, happy to answer any questions that you may have.
Any questions, members? Any questions? Having none, thank you all both for being here. I see no one else signed up for public testimony. If anyone present that wishes to testify on, for, or against Senate Bill 1806, hearing none, public testimony is closed and we'll leave the bill pending. So let's go to the last one, the longest one. 16th, is it 1646?
Yep.
Okay. So we'll have a quorum. We have a quorum. Yes. Chair lays out Senate Bill 1646. The chair sends up committee substitute for Senate Bill 1646. Is there any objection to adopting the committee substitute for Senate Bill 1646? Hearing none, so ordered. Recognize Senator Huffman to explain the bill in place of Senator King.
Thank you, members. It's a pleasure to lay this bill out as a courtesy to Senator King. Members, copper theft is on the rise across Texas. Concerningly, criminals often look to Texas's critical infrastructure like telecommunication cables in search of copper to steal and illegally sell. When criminals vandalize critical infrastructure in search of copper to steal, it is not a victimless property crime. It is a crime that threatens public safety, emergency response, and the lives and livelihoods of Texans. In addition to the millions of dollars in damage caused by this vandalism, copper theft disrupts critical communications that Texans rely on, including access to emergency services like 911. Criminals vandalizing fiber optic cables also negatively affect communities. Because fiber optic and copper cables often run parallel to one another, criminals will cut fiber optic cable in search of copper in telecommunications lines. Every major Texas metroplex in Dallas, Fort Worth, Houston, and Austin is reporting a surge in copper thefts. From 2022 to 2024, Fort Worth experienced a 545% increase in reported cable theft and a 53% increase in all metal theft. Copper theft and associated fiber vandalism are risks to Texas public safety. Senate Bill 1646 addresses this issue by increasing the penalty for the unauthorized possession and unlawful purchase of copper, requiring purchasers to record and report the sale of copper, and tasking DPS with continued education relating to copper theft and its dangers. Senate Bill 1646 is the result of meetings over the past year and a half with law enforcement, prosecutors, telecommunications providers, and local and state elected officials. The bill prohibits the possession of communications material unless authorized. This is a key element specifically requested by law enforcement to help close a gap in current law when an arresting officer isn't present when the materials are initially cut. Additionally, the bill enhances criminal penalties to give police and prosecutors stronger tools for addressing theft and associated vandalism of critical infrastructure and emergency response facilities. Senate Bill 1646 adds security to business transactions to ensure that a metal recycling entity is only purchasing telecommunications materials if the seller is an authorized possessor of the materials. This will help prevent illegal copper wire purchases. With that being said, I want to highlight two crucial points. One, SB 1646 will strengthen penalties for intentional copper wire and fiber cuts that damage critical infrastructure such as emergency services. We've included specific provisions in the bill to protect authorized workers in the field who handle copper wire. Two, most Texas metal recyclers do not engage in illegal copper transactions. However, due to the rising price of copper, there are some bad actors who participate in illegal activities. This behavior must be addressed. The committee substitute corrects drafting errors, including changing the effective date to January 1, 2026 for DPS rules promulgation and revising unrelated language added by Ledge Council. It adds language requested by law enforcement to clarify that the bill does not limit their ability to use existing technology to track stolen goods. It clarifies that damages caused by copper thieves to fiber lines outside a facility's fence are subject to criminal penalties for critical infrastructure damage, and it instructs DPS to develop additional training materials in collaboration with the Metal Recycling Entity Advisory Committee, Metal Recycling Entity Trades, and Communications Companies. That's the layout. And I have a sample if anyone's interested. I have a demonstrative evidence. Somebody, but it feels like a weapon, actually.
Thank you, yes, that's I know when those are cut, my community in Pleasanton just goes out. No communications whatsoever, no cell phone, no anything like that, and so, and it happens way too much. So, with that, any questions? With that, the chair now opens up for invited testimony, and the chair now calls Ron Joy, Anthony White, David Tate, and Jimmy Hoslocker. Ron Joy, Anthony White, David Tate, and Jimmy Hoslocker. We'll begin on my right. And if you state your name, who you represent, and you may begin your presentation.
Thank you so much, Chairman Flores. My name is David Tate. I'm here representing AT&T in support of the committee substitute for SB 1646. And on behalf of thousands of customers who are directly impacted by the alarming rise in vandalism to critical telecommunications infrastructure, I want to thank you for your consideration of this very important bill. The rampant vandalism that we are seeing jeopardizes the state's essential infrastructure, including water systems and utilities and communication networks and emergency response systems. In doing so, it endangers the safety and livelihoods of Texans. AT&T alone has experienced a 60% surge in vandalism and theft over 2 years, from 2022 to 2024, with an average of 20 thefts each week in Texas. The committee substitute for Senate Bill 1646 offers a necessary policy solution to protect telecommunications infrastructure in order to prevent the interruption of essential services for Texas residents and businesses. AT&T fully supports this legislation because copper theft and fiber vandalism not only disrupt vital communications, but it also threatens public safety and national security. We want to thank Senator King for his leadership in this legislation, and I also want to thank you, Chairman Flores, and each member of this committee for your time today and certainly available for questions.
Thank you. Any questions?
Good afternoon, Chairman and members. Ron Joy with the Texas Department of Public Safety. I'm currently the Service Director for Compliance Enforcement in the Regulatory Services Division. Here to testify on the bill and serve as a resource witness if you have any questions.
Any questions, members?
Good afternoon, Chairman Flores and members of the committee. My name is Sergeant Anthony White, and I work for the Fort Worth Police Department. I'm the supervisor of the Fort Worth Police Department Metal Theft Unit, and I'm here in support of SB 1646, which we believe is critical to address copper theft and the public safety crisis across Texas. Like many cities, Fort Worth has seen a dramatic increase in telecommunications wire theft as the price of copper has continued to increase. Thousands of Texas residents have suffered service interruptions, and the theft of telecommunication wire frequently results in prolonged service outages, disrupting 911 availability, flood control, weather warnings, medical devices, business operations, and virtually every facet of our daily lives. The Metal Theft Unit in Fort Worth has carried out numerous inspections at recycling facilities throughout the city to ensure adherence to current state laws and local ordinances. We need to bolster these efforts with a statewide solution, much like we did with the legislation that successfully has reduced catalytic converter theft through the Deputy Darren Almendarez Act. The bill's prohibition and unauthorized possession of communications material is a key element that will help close a gap in the current law. The stronger penalties included in SB 1646 are also necessary to support law enforcement and create a more effective deterrent against metal theft. I'm here to tell the members of this committee that SB 1646 is that tool. We have great working relationships with metal recyclers, and my hope is that they want us to identify these bad actors who are tarnishing the industry's reputation. Finally, we welcome any additional training materials that will be developed in collaboration with DPS, metal recyclers, and communications companies to help us work together to battle this problem. I appreciate the work of the bill authors to collaborate with all interested parties to develop this solution. Texas will be a safer place when SB 1646 is signed into law. Thank you for your time today and your service to the great state of Texas.
Thank you for your service.
Good afternoon, Chairman Flores and members of the committee. My name is Jimmy Haslocker from San Antonio, and I'm chair of Bear Metro 911 Network District, which includes Bear, Guadalupe, and Comal County. I've been the chair for the last 38 years and have worked diligently to build a very robust 911 system. I'm also chair of Operation Game Thief for Texas Parks and Wildlife and support game wardens and public law enforcement around the state. Telecommunications copper theft is a major public safety problem in Bear County across Texas, and we support this legislation as important and necessary to fight. My primary focus today is to share with you the dangerous consequences of telecommunications, copper theft, and fiber vandalism on our emergency communications center. Too often, thieves end up damaging fiber optic communication networks while attempting to steal telecommunication copper wire. That, along with the actual theft of telecommunications copper wire, can take down an emergency communications service or an entire community. For example, a few weeks ago, that severely disrupted 911 service and caused major communication failures in Chambers and Jefferson counties after he vandalized a fiber optic junction box and cut the fiber optic line, mistakenly thinking it contained telecommunications copper wire that he could not steal or sell. The damage and the overall impact of the single incident, including the service outages of businesses and residents and emergency responders, as well, was well worth north of $100,000, not to mention the public safety implications and down 911 system. Also, as chairman of University Hospital in San Antonio, I can tell you that every day one of our biggest fears is someone doing this when you're in a car, when you're in a waiting room at the hospital, whether you're in Bear Metro 911's network district or any other district around the state of Texas. Time is critical, seconds count, and people are important. When they dial that number, they want to get someone to respond to it. And having people cut these cables and do these other things is really costly to the state of Texas and puts people's lives in danger. I also have had my office impacted several times and businesses that I also operate. I want to thank you, Senator Flores, for your leadership and also for the committee's leadership to allow us to be here today to talk about this important thing to help save lives in Texas.
Thank you. Senator Huff, you have a question? Thank you. Thank you all for your service. Thank you for being here, and we appreciate your input as we consider this. Thank you. So as the chair sees no more invited testimony, the testimony is now closed. The chair now opens it up for public testimony. The chair calls Todd Baxter, Mel Wright, Jim Shapiro, and Michael Hayes. Todd Baxter, Mel Wright, Jim Shapiro, and Michael Hayes. Thank you all for being here, taking the time to come discuss this bill. And we'll begin on my right. You state your name, who you represent, your position on the bill, and you have 2 minutes.
Thank you, Mr. Chairman and members. My name is Todd Baxter. I'm testifying on behalf of the Texas Cable Association today in favor of Senate Bill 1646. Our networks are a critical component of everyday life. Our services provide telehealth, telemedicine, education, commerce, financial transactions, and most importantly, as you've heard, critical 911 communication services. And in addition to serving as chairman of the board of TCA, I'm also group vice president of Charter Communications, known as Spectrum, and I have 10 of our 41 states. And damage to critical infrastructure is up nationally, and I'm sad to report that Texas has some of the highest incidences of attacks on these networks in the nation. For example, in 2024 alone, Charter Spectrum saw over 100 attacks in the state of Texas, and it impacted approximately 1 million of our customers, your constituents. Plus, when these cuts occur, resources are diverted from expanding and modernizing our networks that goes to the benefit of your constituents. In short, this bill will provide law enforcement with the proper tools and authority to combat this growing threat to our customers and your constituents, and we respectfully request the support of this bill and do thank you, Mr. Chairman, for your support and your leadership on this issue. Thank you.
Thank you. Welcome. State your name, who you represent, your position on the bill, and you have 2 minutes.
Good afternoon. My name is Mel Wright, second-generation owner of Wright Scrap Metals, Beaumont, Texas. We were founded in 1968. Chairman Flores and members of the committee, thank you for allowing me to testify respectfully in opposition to Senate Bill 1646. We commend Senator King and his staff for their engagement with us over the past 2 months. I'm also the current president of the Recycling Council of Texas, trade association representing hundreds of Texas companies that are metal recycling entities, or MREs. We're regulated by the Department of Public Safety. I'm here strongly in support of the DPS and the MREs in the state who are also victims of metal theft. We fully support increasing penalties, empowering law enforcement with the tools they need to catch, prosecute, and track the crime. MREs have become a first line of defense for stopping metal thefts. MREs records, we record and report metal purchases to the DPS. We help maintain a statewide metal theft alert system with local law enforcement. We conduct training and education programs for officers to help them track metal theft. In our experience, property thieves, when caught, face very little punishment, which gives these thieves little incentive to stop. We ask that lawmakers not criminalize metal recyclers and stop adding regulations to our highly regulated small businesses, and instead support increased law enforcement resources and penalties to deter property theft. There are over 600 licensed MREs employing 50,000 workers in your districts, paying more than $1.5 billion in annual taxes across the state. MREs are not bad guys. We appreciate the continued work of this committee, the legislature, and all relative stakeholders for their leadership on this issue, and we look to be a continued partner with you all on this. Thank you.
Thank you very much. Thank you for coming over from Beaumont.
Thank you. My name is Jim Shapiro, and I'm fourth-generation owner of Austin Metal and Iron, and I serve as a representative on the Texas Metal Advisory Committee led by the DPS to work together on solutions for metal theft. Thank you, Chairman Flores and members of the committee. Thank you for allowing me to testify respectfully in opposition to Senate Bill 1646. Thank you to Senator King and his staff for their engagement with us over the past 2 months. Unfortunately, the legislation being discussed today was not brought before our advisory committee prior to the session, which has been common practice for over a decade. Senate Bill 1646 attempts to stop copper theft by creating additional regulations for licensed MREs that will make it harder to do business while not solving the problem. Copper is a common material used by everyday citizens for legitimate purposes. The bill as filed will make it illegal for an ordinary citizen to be in possession of copper and could unintentionally criminalize people trying to legally recycle copper. It is already illegal to buy burnt communication wire. If an MRE buys insulated communication wire like the AT&T wire, then current law requires us to record and report to the DPS the seller's driver's license, license plate, make and model of their car. If the seller requests cash, then we must fingerprint the individual, register with them at the state of Texas, and mail them a cash card to redeem upon receipt. Our business continues to work as an active partner with DPS. 2 weeks ago, along with DPS, I hosted Senator King and Senator Birdwell's staff to demonstrate the reality of the comprehensive regulation MREs comply with today. We are here as a partner with the state on this issue to help ensure regulations make sense and make a difference. Thank you.
Thank you.
Yes, sir. Hello, my name is Michael Hayes. I'm with Greater Harris County Emergency Network, 911 Emergency Network, and I'm the IT officer. So we serve Harris and Fort Bend County and 37 police, fire, and EMS districts. We deliver 911 calls, and we are in support of this bill due to the rampant fiber vandalism. And I've provided pictures there. I know Senator Huffman had an actual piece of fiber, but those pictures in that written testimony there are photos of crews going out and having to repair, and the restoration time on these is 12 hours. So if let me say that in the major metro areas, we are blessed to have lots of fiber, and we'll have multiple fiber providers. So I'm saying this to y'all that serve rural districts. You may only have one fiber line going out to a police or fire department or out to a microwave tower. So if that gets cut, you could have the whole county's public safety infrastructure go out as far as communications. So that's all my testimony. I'll be open to any questions.
Thank you. And I have had that happen in my county, in where I live, a number of times. Of course, a number of those times, in all fairness, that was excavation that dug and knocked that out. I guess the main issue here is, and I'll ask this for the MRE gentleman, is you talked about working with law, and we appreciate that. I don't think that the majority of your industry is talking about being, helping out to make it easy for people to do this. I mean, obviously, they're doing it because they have somewhere to sell it, and so normally they're not going to go to another state, although they might, but to go to another state to go sell it, that's more lenient than Texas. But they're doing it because they have a place to sell it. So if they showed up with a whole roll of wire like that right there, what you're telling me is if it's insulated, if I heard you correctly, that you had to report it, fingerprinting, and so I guess the intent of this bill is, from what I see it, is to make it harder. We're just mainly dealing with that. With that's what we're talking about, is the optic cable and everything, and of course everything that's connected with the functionality of our modern society is on that right now. So My question to you is, you mentioned more, perhaps we should look at more effective ways, is what I heard you say. What's that? What do you mean by that? If you can tell us what you mean by that?
Yes, sir. There's several things that they catch these thieves all the time. And I'm in Travis County. Nothing happens in Travis County. And we're the victim as much as we are the solution. So we get broken into all the time too. I've been helping pass legislation up here at the Capitol for 15, 16 years. And we will do anything to fight metal theft. And we think there's some language that we've suggested to our opposition that they just don't seem to listen to us and take our suggestions. They put it all on paper and handed it to us at 8 o'clock this morning, and we have to review it, and we're here today to testify about it. So we're willing to work with everybody to come up with a solution. We need them to listen to us too.
All right, and that's what we're here to listen to you and see what you have to say, and so of course, as we're looking at the intent of this bill, I don't think that anybody sitting in front of me disagrees with the intent of this bill, what Senator King is after, and what you all are after. It's just how to get there. Sometimes is a matter of working together with the different stakeholders, but achieving that objective is kind of what's important. So you talked about Travis County, for example, that says letting them go. So where do you think they're selling this stuff? Where do you think the thieves that are hitting Travis County sell this cable? I mean, if you had to say an idea, are they doing it locally? Are they driving to Houston? Or are they driving to San Antonio? Houston, that's a long way. But you know what I'm saying? That if they're engaged here, if there are that many, and of course they're saying we're not going to get prosecuted. Obviously, they're selling it somewhere. They're not doing it just to collect it in their garage. Correct. So what do you think about what? I mean, just you don't have to say, oh, so and so is doing. No, is it? Well, you think they're selling it local? My point is there a loophole there of some places that they're going to go sell?
Yeah.
That perhaps you can close and address this effectively.
We work hand in hand with DPS and our local law enforcement, and our industry's kind of like your industry and everybody else's industry. We have our bad operators, and the thieves know where to sell the material. So if you have, thousands of MREs across the state, it only takes one or two in a general area, and they go to these different areas. And we passed legislation years ago where we work with DPS, and they're now doing inspections a minimum of once a year, sometimes twice a year on different MREs. So there is enough legislation, laws on the books right now to prosecute these people. It's a state jail felony if you sell 1 pound of copper. All of this copper is it's there. I got broken into 2 weeks ago. They stole $30,000 worth of copper, drove through my warehouse, through the thing, and I had to call 311. I never even got a detective, anybody at my place. So there's a lot of laws on the books that most law enforcement would agree with is there if it was enforced.
Okay, so you got the committee substitute today, right? So have you take time to look at it?
Yes, sir.
And so what's the main rub?
You want to?
Sure. The main rub is their definition of it's copper or brass, which includes everything. Copper's an element, so it's in your vehicles, it's in washers and dryers. How ridiculous do you want to get with the definition of copper? How far do we stretch it? If you take down your Christmas lights when you go to recycle them, do you have to bring an ownership document that those are your Christmas tree lights, that instead of putting them in the trash, you decide to recycle them? Same thing with the extension cord that you accidentally whack with your weed eater or whatever and cut the cord. Those are common items that everybody has, and it's just the other point I was going to make too about MREs is MREs register with DPS, but that doesn't mean there's not other people out buying copper. If you're an unregistered person, it's against the law to buy copper without being an MRE, but then you got to catch them. So that's kind of a rub with some of us that are in the business, is we follow all the regulations, but then you have what we call pop-ups, you know, kind of a black market deal, put an ad in a newspaper or a day trader deal or Facebook. I mean, there's lots of different areas that create problems for people that choose not to follow the law. And the other important point was we talked a lot about fiber optics, and fiber optics contain no copper. So unfortunately, when they cut it and they don't see copper, then that's a problem. So I don't know, I guess we got to educate our thieves that the fiber optic is not going to contain any copper. And it's my assumption that AT&T is moving more towards fiber optic and away from the copper. I know they did that to me at my business. They wouldn't support my 5 lines I had coming in anymore. So.
Okay, but thank you. We just wanted to hear, both sides. And, of course, you all want the same thing. Senator Hagenwood, you have a question?
Yes, sir, Mr. Chairman, thank you. Mr. Baxter, just trying to get another perspective on this MRE. You work in the industry, so maybe you have a little bit of an idea. It seems to me that a good actor, someone who's registered, who's not black market setter, has nothing to worry in this bill. Those that aren't, of course, would have. What's your perspective on the concern that this is too tough on MREs?
Yeah, so 2 things. Thank you for the questions, very good questions. As you know, I've been in this industry for longer than I care to admit now. I've been working on this issue now since I entered the industry. 10 years ago, you heard reference to the cash card. At the time, we'd hoped that would address the problem. And when you look at how bad the problem has gotten, there may be some laws on the books, I agree with that. But what's on the books is not working. And we work closely with law enforcement, and they tell us that what is there is not adequate. That's why you're hearing them today talking about the need to do something more. The other thing I would say is I will respectfully disagree with the sort of explanation or narrative that, anybody can have this. But in the committee substitute, if you look closely, and this was probably in the original bill too, the unauthorized possession of copper and brass material is defined under the Occupations Code, which clearly says is the type of brass and copper material that are things like power inverters and copper used by utility and telecom. So if it's just like, regular copper, speaker wire, or even, copper sort of plumbing materials, none of those things are affected by this bill. So I think this bill is very drafted very narrowly and drafted very well to make sure that it is only addressing the types of copper and brass material that is being pulled down off of our lines, our poles, and being cut and taken down. So I do think that the bill has been drafted very clearly and very narrowly on that front.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Hagenbooth. Thank you. Any other questions, members? Thank you all very much for being here. Thank you for your testimony. So there's no one else registered to testify on, for no more public testimony registered. Is there anyone here wishes to testify on, for, or against committee substitute for Senate Bill 1646? Hearing none, public testimony is closed. And we will leave this bill pending. So the chair calls up Senate Bill 1124. So the chair moves that Senate Bill 1124 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes and 0 nays. Senate Bill 1124 will be reported to the full Senate with a favorable recommendation. Senator Huffman, do you wish this to be local and uncontested? Sure. Senator Hagenbu recommends that Senate Bill 1124 be recommended local and uncontested. Any objection? Hearing none, so granted. Sorry. Next one.
Okay. 1372.
I'll protect, but just in case something goes.
Chair calls up Senate Bill 1372. The chair moves that Senate Bill 1372 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes and 0 nays. Senate Bill 1372 will be reported to the full Senate with a favorable recommendation. Wish to go local? Senator Hagenbu moves that recommends that Senate Bill 1372 be recommended for local and uncontested. Any objection? Hearing none, so granted.
1930.
Chair calls up Senate Bill 1936, and the chair moves that Senate Bill 1936 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes and 0 nays. Senate Bill 1936 will be reported to the full Senate with a favorable recommendation. You wish to go to local? Senator Hagenbu recommends that Senate Bill 1936 be recommended for the local and uncontested calendar. Any objections? Hearing none, so granted.
1937.
Chair calls up Senate Bill 1937. Chair moves that Senate Bill 1937 be reported to the full Senate with a recommendation that it do pass favorably and be printed. Clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. Senate Bill 1937 will be reported to the full Senate with a favorable recommendation. Senator Hino has wished the bill to be local. Senator Hagenbu, you're doing a lot of so Senator Hagenbu recommends that Senate Bill 1937 be recommended for the local and uncontested calendar. Any objection? Hearing none, so ordered. Chair calls up Senate Bill 552. So the chair moves that Senate Bill 552 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. Senate Bill 552 will be reported to the full Senate with a favorable recommendation. Senator Huffman, do you wish this bill to be recommended? This bill will go to the floor. So ordered. Chair calls up Senate Bill 1208. The chair moves that Senate Bill 1208 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
Every 4 ayes, 0 nays. Senate Bill 1208 will be reported to the full Senate with a favorable recommendation. Senator Huffman recommends Senate Bill 1208 be recommended for local and uncontested. Any objection? Hearing none, so granted. Chair calls up Senate Bill 1806. Chair moves that Senate Bill 1806 does not pass, but that committee substitute for Senate Bill 1806 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles. Senator King. Senator Hagenbu.
Aye.
4 ayes, no nays.
There be 4 ayes, 0 nays. Committee substitute for Senate Bill 1806 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends a committee substitute for Senate Bill 1806 be recommended for local uncontested calendar. Any objection? Hearing none, so granted. Chair now calls up Senate Bill 1646. The chair moves that Senate Bill 1646 does not pass, but the committee substitute for Senate Bill 1646 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles. Senator King. Senator Hagenbu.
Aye.
4 ayes, no nays.
There'll be 4 ayes, 0 nays. Committee substitute for Senate Bill 1646 will be reported to the full Senate with a favorable recommendation. Senator Huffman recommends committee substitute for Senate Bill 1646 be recommended for local uncontested. Any objection? Hearing none, so ordered. Did that get them all? Members, is there any other business to come before the committee at this time? Hearing none. Senator Huffman moves that the committee stand in recess, subject to the call of the chair. Thank you, members.